Hi everyone, you're watching the virtual Amicus and I'm Jay Lodha. Well, memorandum of understanding that is entered between the parties that are filing for divorce by way of mutual consent. Now, what happens if they fail to do so? Can the wife or the respective spouse claim maintenance even after the mutual consent decree is delivered by the family court? Why is it that it is the most preferred way or the most peaceful way of parting ways, which is divorce by way of mutual consent? And under what provisions of law is it governed? Now, talking about alimony, under what provision of law is alimony governed in India? Can both the wife and the husband, or are they entitled to claim maintenance for their respective spouses? Is there a special legislation, or they are governed by Hindu Adoption and Maintenance Act? Talking about surrogacy. Now, surrogacy broadly is defined as a practice where a woman gives birth to a child for an intending couple with the intention to hand it over to them after the birth. Now, does there have to be a statutory, is there a requirement as such under the statute that mandates the relation between a mother of a biological mother and a surrogate mother? And who can avail surrogacy? Is there a difference between a commercial or a regular surrogacy? And who regulates it? Are there committees that are enshrined under the provisions of the Act? Now, talking about adoption, who all are eligible or who all are allowed to adopt a child in India? Can an NRI do so? And under what provisions of law is adoption governed? So today we decided to seek assistance because it's a very important topic. It's on family laws. And we decided to seek assistance from someone who has worked extensively in matters relating to divorce, maintenance, custody, restitution of conjugal rights. She's also advised in matters relating to adoption and surrogacy. In short, she's an expert in family court matters and she is a specialist practicing in that field, and she's practicing as an advocate before Honorable Bombay High Court and Family Court. So to give you all a brief introduction about Amicus for today's session, today we joined by Miss Shaili Muzoomdar, Advocate, High Court and Family Court, who graduated from Government Law College, Mumbai back in the year 2012. And she subsequently had enrolled herself as an article clerk with Haryani and Company Advocates and Solicitors. And she gathered considerable experience in the field of real estate and corporate law. And she's represented India as a student ambassador in the International Peace and Conflict Resolution Program called Seeds of Peace. She's visited countries like the US, UK, Germany, Pakistan, Jordan, Morocco, to name a few, to participate in international peace conferences and cultural exchange programs. She was awarded the Rotary Youth Icon for the year 2005-2006 and was a president of the Interact Club for the year 2005. She's also a member of the Indo-American Society and has served as a president of a chapter in Business Networking International for the year 2021. Also a member of international community called GATHER, Gather, and represented India as the only Hindu in Muslim Jewish conference, which was held in Berlin back in 2015. She's also been part of the internal complaint committee on prevention of sexual harassment of women at workplace. So thank you so much, ma'am, for taking out time for doing this session. For the first time on the virtual Amicus, we have a speaker who will be covering four different topics, but as an offshoot of the same field, which is family law, which is topic number one being divorce by mutual consent, topic two, maintenance alimony laws, topic three, adoption laws, and topic four, laws governing surrogacy in India. Anything that you wish to say before we start with your session?
First of all, thank you so much, Jai, for having me on your channel. I think what you are doing is really, really amazing, especially for new lawyers who are looking to join the field. I don't know about expert in family court or family divorce matters, but I'm definitely an enthusiast if that counts. And I am really looking forward to having a discussion on the topics that you mentioned.
Very well, ma'am. So the stage is set. The floor is all yours. If you could proceed with divorce by way of mutual consent, we would love to see and take your insights, followed by a quick Q&A session. So the floor is all yours. Topic divorce by mutual consent. Over to you.
Okay, thank you so much, Jai. Okay, so first and foremost, I want to address the fact that somehow divorce in Indian society is still looked on as a taboo, right? When we talk of divorce, we necessarily talk with a certain sigh, with a certain sense of disturbance about it or disgust about it. What I want to do is say that we need to remove this taboo, right? A lot of people are scared to come into this practice because they're like, if we are going to practice as a divorce lawyer, how is society going to look at us? And what do they call us, the home breaker or whatever? So here is one misconception I really, really want to clear out there. A divorce lawyer or a matrimonial lawyer is not a home breaker or a house breaker, right? If an earthquake has taken place in a marriage and the marriage has already broken down, the earthquake has taken place. We are not the one who caused the earthquake. In fact, we are the rescue team that comes to salvage whatever is possible from the rubble of a broken marriage. So I think that attitude really needs to change towards a divorce lawyer. A divorce lawyer can in fact make you cope with your conflict in a much better way, because conflict is not in your hands, right? If it happens, it happens. But there is definitely a way to resolve the conflict with some dignity and in a manner which is least dangerous for all and troublesome for all around you. So, talking about divorce, there are two main ways of getting divorce. One is, of course, divorce by mutual consent, which is the topic at hand right now. And the second would be, what if one cannot manage to take a divorce by mutual consent? One, what do I mean by divorce by mutual consent? Both the husband and wife know that the marriage has broken down. They have tried reconciling their differences, but they are not successful in doing so. And they have both jointly reached a conclusion that they need to go separate ways. In my opinion, mutual consent way is the best way to rip off a band-aid, right? There is always going to be pain, but at least this is swift and it will cause you the least amount of pain. When I say divorce by mutual consent, both the parties, that is husband and wife, are filing a joint petition to the court, letting the court know that our marriage has broken down, we have differences which we cannot sort out, and hence we have decided that based on certain consent terms that we have agreed upon, we would like to go ahead and go our separate ways. The court gives you a time of 6 months from the time of filing of the petition. After 6 months, if both the parties are still sure on the decision that they want to go ahead with the mutual consent, the court grants the decree of divorce based on the consent terms. Now, when I say consent terms, what are we including? Consent term mainly depends on these 5 parameters. In mutual consent, the first thing that we need to consent to is alimony. The partners decide, usually given the patriarchal society of India, what husband is supposed to pay to the wife. This can be a monthly settlement, this can be a yearly settlement, or this can be a lump sum amount towards a one-time settlement of her alimony and maintenance. Second comes child custody, if there are children involved in the marriage. Who will be keeping the children on day-to-day basis? One, that is physical custody of the children. Second is the legal custody, that, the important decisions regarding the children's future, who will be making those decisions. So child custody is second. Third is child support. Who will be paying, regardless of who the children live with, who will be paying for the children's expenses, education, medical, miscellaneous, entertainment, etc. That is something which is decided between the couple. Fourth is joint property. If the husband and wife share a property jointly, because their marriage is ending, how do they want to dispose it off? One needs to come to agreement regarding that. And fifth is freehold. Whatever is gifted to the wife during or after her marriage by either side of her family is her property legally. So when I talk street, then I mostly mean valuables and jewelry. So how is that going to be distributed? What needs to be done about that also forms a very important part of the consent terms. I would say, as a divorce lawyer, your job is to guide your client correctly on each of these points and to help them reach clarity regarding what is it that they want. And once they have told you what is it that they want, then to try and negotiate with the other side and reach a best compromise, a best settlement, which is beneficial for both your client and the other side. As I said, you file the petition for mutual consent jointly. 6 months go, and if you are sure that you still want the divorce, the court grants you the decree of divorce after ensuring of compliance of consent terms.
Very well. So can we have like a quick Q&A session on this? So question number one, when you talk about divorce by way of mutual consent, are both the husband and the wife entitled to maintenance, or is there a difference between interim maintenance and final maintenance that is awarded by the court?
Okay, so now, Jai, when we talk about interim maintenance and final maintenance, we need to understand that.
Yeah.
So, just always, of course, the difference between interim maintenance and final maintenance. Interim maintenance is what is granted to the wife, usually to the wife, during the proceedings of divorce which are going on in the court, right? The wife needs to sustain, wife needs some amount of money to take care of her expenses, even while the matter is going on in the court. Final maintenance is what is awarded to the wife at the final stage, at the time of passing of the final decree of divorce. Interim maintenance is supposed to be a summary proceedings, while final maintenance, of course, goes far more in detail, regarding income of the parties, the lifestyle of the parties, the wealth of the parties, etc. In mutual consent, because there is 6 months between the cooling off period, which is supposed to be granted is 6 months, there are clients who can still opt for interim maintenance during those 6 months, which will be mutually decided between the parties, or the party may decide to take a lump sum amount at the end as final maintenance. The most important part about mutual consent is that whatever it is that you are deciding, you are doing it after mutual discussion, and you are consenting to it. Both the parties are consenting to it. That's the essence of a mutual consent divorce.
Very well. Going ahead with our next question, can the parties, if they mutually decide to end everything, right, the end the relationship between them, can they mutually waive off the mandatory cooling period, or is it still mandatory? Because there are a plethora of Supreme Court judgments on this, that if the parties wish and opt for cooling off, waiving or getting the cooling off period waived, they can very well do so, and probably in the second or the third hearing, the matter can be finally resolved and the decree of divorce can be out.
So, yes, there are plethora of Supreme Court judgments. Some courts are willing to waive off the cooling off period. However, the majority of court, it's at the discretion of the court, but the majority of courts are still opting to keep that 6 months as the cooling off period. A lot of times, the 6 months are also required for complying with the consent terms. For example, if there's disposal of the joint property that is involved, that requires some time. So mostly we are still looking at 6 months, but hoping soon that that may change.
And why is it that physically both parties need to be present on the first date of hearing at the time of institution? Their signatures are required. Can't this whole process be done away with? Especially we're living in a COVID era, and it's not possible for parties to fly in, fly out every time on a date of hearing. You need to sign on those crucial papers. And for counseling, why is it even that the counseling, they've made it mandatory? This is something that we've seen in Rajasthan in most of the family courts here, that initially when when this institution takes place and the parties are asked or directed to sit with the counselor and see if counseling works for them and or if issues can be resolved, is it mandatory under the provisions of law that you have to sit with that counselor and answer all those questions that are posed to you, all private questions?
Okay, so first of all, one has to understand that the counseling is done more from a point of view to ensure that both the parties know what they are doing, what they are getting into. For a layman, it's not always easy to understand the legal implications of their actions. The point of counseling is not to grill the people about what is their decision regarding marriage or what is the reality of their marriage, but so much they want to ensure that the whole mutual consent, the essence being consent, is obtained free of any undue force, and the person is realizing while consenting to what is it that they're consenting to. As long as the counseling is concerned, your question, the court has been very kind and very cooperative in a way that if you make application that your client is out of town or not in a position to come physically to the court, it can be done via virtual means, like through virtual calls. Of course, it is at the discretion of the court to grant it or not. But as I say, courts are cooperative when it comes to mutual consents. And as long as the signing and everything is concerned, I personally do believe that if you are going to be filing for divorce, and that is such an important personal decision, personal step for you, as long as filing is concerned, there are, of course, ways to do it otherwise, but I would very much ask and require the parties to be there at least for the signing purpose. As long as the first counseling goes, there are ways we can request the court to, give relief through some virtual means.
And lastly, once the decree of this particular divorce by way of mutual consent is out, can it be subsequently challenged? Let's say there is a change of heart and the parties have decided to get back, or no, can it be challenged mutually in a court of law in the first appeal?
the whole point of consent, mutual consent divorce, is that the consent is being given. The point of counseling, as I said, there is first counseling and there is counseling on the day of the decree of divorce, is to ensure that the parties are very sure of what they are doing. There is consent, free consent. Only when the counselor is sure that everything is in order will the counselor give a report to the judge stating that the parties are ready for divorce, all the compliances are met with. Only and only after ensuring that and judge being personally sure that the parties are ready for divorce is the decree of divorce granted. So then the question of appealing that becomes slightly redundant. As long as it boils down to you gave your consent freely, in sound mind, without any force or coercion, then where is the question of then taking it back? And as long as, yeah, but if the compliance is not met with, for example, if there are access terms between the parties regarding the children, one party is physically keeping the children in custody and the other party has visitation rights. If those are not being followed on by the other party or by one party, yes, then the party who is the victim or is seeking relief can always approach the court stating that these are the consent terms decided between us and the other party is not following with that.
So there you go. That was our first segment on divorce by way of mutual consent. I still fail to understand why continues to be a taboo in India, because it should be ideally one of the most preferred ways, one of the most peaceful ways of parting ways, just like a normal breakup.
Absolutely, Jai. In fact, because this is such a serious topic, I usually like taking, or speaking about with in a little lighter vein. And that's what I always say that, it's a marriage, not a race. It's a marriage, not a race. Stay in it for love, not to save face. Like if fights are rising at a frightening pace, and if of love there remains no trace, then you really need to reconsider, seek help in form of counseling, in form of whatever ways. But don't don't think of divorce as death or as a taboo. It's there are things that happen in a relationship, that happen in life. What really matters is how you conduct it and how you go about it.
Correct. So now, going ahead with topic number 2, which is maintenance and alimony laws. So the stage is set. The floor is all yours. Over to you.
Okay, so when it comes to alimony and maintenance, as we know that under Hindu laws and the other personal laws, husband is supposed to maintain the wife and maintain her in a way that is suitable to their standard of living. If the husband fails to provide maintenance to the wife or spouse fails to provide maintenance to the other spouse, then the other spouse has the right to go and approach the court, stating that I am being deprived of my right to maintenance and it is unfair to me. You lay down the facts in a petition, you file a petition for maintenance. The court will, of course, look at do the trial and accordingly ask the husband or the spouse to grant the necessary maintenance. This I'm talking about just maintenance petition. Coming to alimony, which happens in the divorce case, as I explained earlier, there is interim maintenance which is to be granted to your spouse during the proceedings are going on in the court. That is one thing, one aspect of it. Second aspect of it is permanent alimony maintenance. If the decree of divorce is being granted, then what is it that the wife is what share of wealth or maintenance the wife entitled to, that is decided pretty much at the end. There are several laws under several acts in the Hindu Marriage Act, Islam, Christian Parsi law, Indian Divorce Act. And maintenance alimony really becomes a very conflicted issue. In fact, it's one issue on which there is maximum debate. But yes, there are ways that that also can be worked out. And one of the reasons why counseling is helpful in matrimonial matters is that if the parties can sit with the counselor and if the counselor can help them reach a settlement regarding these topics, it really saves time not only for the court but more importantly for the couple.
There you go. So thank you so much for all the valuable insights on alimony and maintenance. Now let's quickly start with our Q&A segment on alimony and maintenance. So question number one, the parameters that are laid down under the Hindu Adoption Maintenance Act, are the parameters the same for other legislations and for other communities as well? For example, alimony under maintenance law, Christian law. And another question, which is a part of this, is what how does one quantify how much amount to pay? Are there calculations or are there formulas that are enshrined in the provisions of the act, or it totally depends on facts and circumstances of every case?
So, Jay, honestly, it depends. It really depends on the discretion of the court and facts and circumstances of every case. However, to just say general principles which are applied and which court takes into account is that this wife is entitled to maintenance in accordance with the standard of living she enjoyed while she was married. Just because she's seeking a divorce or a divorce is being sought against her does not mean that she should be left bereft without that kind of security, financial security that she was given while the marriage was working out perfectly. It usually depends, of course, on income of the spouse, the expenses of the household. Some people, the income may be X, but a majority of it may go towards fulfilling other liabilities and other duties. For example, you may have aged parents, or you may have loan expenses, XYZ. So the court really takes into account all these factors: basic standard of living, income, expenses, liabilities, overall wealth, and accordingly decides the final permanent alimony and maintenance. And no, the laws are not the same under all the personal laws, but the principles remain pretty similar.
Very well. And question number two, can the husband also claim alimony? Is he entitled to alimony?
And
Because
then
in almost all the cases we've seen that the wife is in certain way, there is the flavor of this particular legislation being a woman centric legislation. So
I know in the Hindu personal law, the husband can also claim alimony or maintenance against the wife. I wouldn't call it very women centric because I feel that this was essentially created to protect women, because we came from a setup where women were not necessarily working outside marriage. Of course, that is changing. And while that is changing, so are the judgments. There are judgments of the Supreme Court which very clearly say that alimony or maintenance does not have to be a dole out from the husband, right? The court also takes into account the wife's qualifications, her capacity to earn, whether it's compromised, whether it's she's fully capable of making that kind of earning for herself. So all these factors are really taken into account, and it would be unfair to color it in any sexist way.
there you go. That was topic number three on surrogacy. And now, lastly, we just left with one more topic now. And if you're ready, you can start with your session on on adoption laws. So it's floor is all yours.
Okay, thank you so much, Jai, for a topic very close to my heart, which is adoption. Uh, as the common saying goes, adoption is where the child grows in the mother's heart instead of the mother's tummy. And I think even the idea of adoption is such an altruistic one, and something I would think is very, very selfless, because here you are loving the child not because there is a blood relationship, but because there is something greater than that. And I think that's a very, very pure form of love. Adoption is covered under Hindu Maintenance and Adoption Act. It is also covered under the Guardians and Wards Act and under Juvenile Justice Act, mainly. Uh, Given your facts and who you are placed under either of that, whichever act will apply to you. Adoption is taken very seriously in India. They want to ensure that this process is not being misused, which is why there are rules and regulations. I often hear couples complaining about this, about the rules and regulations, that there is far too much procedure. But one has to understand that this is being done again to ensure that there is no foul play. Uh, Nowadays, everything is regulated by PARA, which is the central authority which takes care of the adoption. You need to apply you need to basically for being eligible for adoption. If you're a married couple, you need to say that you're a stable marriage, and there are other parameters to make sure that the couple is ready for adoption. If you are a single parent trying to adopt, if you can adopt in India, yes, even if you're a single parent, provided you are a major. However, if a man wants to adopt a girl child, there has to be at least a difference of 21 or 25 years between them, and same goes for the women. Ideally, in adoption, if you already have child of one set, then they try not to give you the in adoption the same thing. But of course, there are preferences. You can say that this is what I want. Now, adoption again falls into two brackets. One is adopting someone that you already know, and that essentially falls under the Hindu laws. There are ways to take care of that, adopt someone that you already know. Second is where the couple is childless and they go to the agency and write their name and say that look, we are unable to reproduce, or whatever may be the reasons we want to adopt the child. Ideally, the process is required to be soon, within 2 or 3 months, but of course it takes longer. The Kara and the other state authorities want to ensure that they want to check your credentials, and once that is done, of course there is further process of familiarizing the child with you, whether there is any sort of friction between the child and the adoptive parents. And once everything, you can present the petition to the court, and once the authority and the court ensures that this is a safe place for the child to go and it's beneficial for both, the adoption decree is passed.
So I think I'm pretty much at peace with whatever you said. So whatever questions that I had have pretty much been answered. So thank you so much, ma'am, for taking out the time for doing this session. It was more like a conversation turning into an erudite discussion. For all the valuable insights, for all the experiences that you shared with us. I'm sure it'll immensely benefit all the viewers who are watching this on family law. You spoke about surrogacy, adoption, maintenance, alimony, divorce by way of mutual consent. These discussions are so very important, and coming from an expert, it does help in solving so many queries. To all the viewers who are watching, our email is mentioned on the channel. In case if you still have any queries, feel free to write to us. We'd be more than happy to forward the same to our amicus for today's session, Ms. Shaili Muzoomdar. So anything that you wish to say, ma'am, as parting words before we wrap this up?
I think the only thing I need to say out there is that there is no right. I mean, in law, there is, especially matrimonial law, there is no right and wrong. It's just that there is a dispute, there is a conflict, and you have an opportunity of helping someone when they're at a very vulnerable place in their life. So please understand to deal with them sensitively, to be there for them. Don't go strictly by the professional etiquette that applies in other fields of law, because this is different. This is personal life. And for everyone out there who still thinks that divorce is a taboo, uh, I can only say this, that it's, you are better single than bitter married, because conflict is to be resolved, not to be carried. And if you can help someone do that, just make sure that you guide them towards as much peaceful process as is possible.
That you ended it the way you started it. Phenomenal session overall. So thank you so much once again. It's goodbye for now.
Thank you.